Hi, welcome to my insane explanation of Rule 12 in Federal Rules of Civil Procedure. Okay, let's start. It all starts, where is my marker? It all starts with 12B, right? So 12B basically are those defenses that the defendant can raise in response to a claim that has been sent to them, right? So 12B has several defenses you can raise in terms of procedural law, right? So this is focused on procedure, not substance. Affirmative defenses are based in substantive law. We are talking about procedural law, right? So how this claim, complaint, whatever moves through the system. Basically, right, 12B, you have several different choices in terms of response, right? So let's say you get your little complaint, you say, what the helly, why am I getting sued? Don't worry, you have 7 options. Well, possibly 6. Don't take my word for it, okay? You have several options, literally. 1 and 2, right, are issues with subject matter jurisdiction and personal jurisdiction. Number 3 is an issue of improper venue. Number 4 is an insufficient process, right? So they were like, well, you didn't give me notice, correct notice, okay? Number 5 is insufficient service of process. So that's saying, hey, my mailman threw out my notice in the trash. I didn't get it, okay? You're gonna bear with me here, right? So insufficient service of process, that is number 5. Number 6 is failure to state a claim. Failure to state a claim gets to be a little messy because that has to do with Twombly, Iqbal, right? Factual pleading versus plausible factual pleading. That's a whole other thing in itself, but we're gonna omit that right now. We're not gonna focus on that. We're focused on our complaint and raising our defenses, right? So then we have 12B7, which is failure to join a party under Rule 19C. Can I tell you what that means? No, so don't ask me. Lovely. So we have all these affirmative defenses. Sorry, not affirmative defenses. Strike that. Strike 12F. Strike the motion. See what I did there? Okay, anyways, you have all these defenses. They need to be made prior to pleading if it's responsive, right? So 12B6 often results in a motion to dismiss, right, if found that there is actually failure to state a claim. That's just something to know. So, moving on from 12B, right, we have all these defenses you can raise, right? You do that in either a motion, right, which is dependent on the judge. You're asking the judge to take action, right? Or in responsive pleading, which puts it upon the defendant. So if I was the defendant, it's on me to choose these and communicate that via responsive pleading. Now, there are some exceptions to the time frame in which you could respond, and that's based on 12B4A and 12B4B. So 12B4A, right, it says that you must respond within 14 days of being served, right, unless, there's our conjunctive, they're postponing the disposition, right? So they're putting off that trial. They're saying, hey, we're going to do this in a month. I ain't got time, okay? I have 20 law readings to do. I don't have time. Postponing the disposition, or they're denying the motion. 12F. That's just kidding. That's striking the motion. 12F, strike that. Strike that, okay? Denying the motion. They're saying this isn't happening. 14 days unless they deny the motion or they are postponing the disposition of the case, okay? So under 12B4B though, sometimes when you get a claim, you read it and you go, dog, what am I getting sued for? This is too vague. This is too ambiguous. I cannot respond to that, okay? When that happens, you go to 12E, right? You ask for a more definite statement. So 12E, you go, hey dog, can you tell me a little bit more? so I can respond to you. XO, send, right? The court, you send that to the plaintiff. Little p, little pi. You send that to the plaintiff, right? And they go, sure, dog, sure, right? In that case, 14 days. You get 14 days, okay? But if the plaintiff does not respond to that, they go, that wasn't cool. They go, no. Then the court oftentimes will move to 12F to strike. Right? That from the record. Things get struck from the record for multiple reasons. One of them can be redundancy. Another can be impertinence. One can be scandal. And last but not least, what is the last but not least? Oh, it can be immaterial, which is what we're referencing with 12.4b. Okay, 12b, 4b, sorry. That's immaterial, so it gets struck from the record, right? So the court can do that by acting on their own, or a party can file a motion to strike things from the record, right? They need to do that before responding or within 21 days of responding, okay? So now that we've covered all this, right? There's one more thing to mention about 12b. So, by raising these defenses, the way you respond depends on how you're allowed to respond. Let's put it that way. So, basically, if responsive pleading, right, if that's on me to respond, I am totally allowed to bring up any one of these 7 in my answer. A reply and an answer are 2 different things. But anyways, we're gonna stay on in my answer. Okay? A reply is ordered by the court. An answer is just me responding. But let's say that you're going through motions, right? Something that motion, or you're just going straight to trial. Okay? In trial, you can take, because you're not responding in paperwork, right? You're showing up and you're saying, hey, I saw that you're suing me, and here are my defenses. So you can take any one of these 7. You can join any of them together, and it is perfectly okay as the defendant to raise any of these 7 in defense of this claim at trial. Lovely. We've done all this, right? So that's 12b. We've covered 12b, 12e, 12f. What else have we covered? I think that's it so far, right? So moving on from those, okay, we're going to talk about 12h and then 12g. So let's start with 12g. Now, when we're responding to our 12b, when we're choosing our 12b defenses and responding, right? 12g basically says what we can and can't do. So 12g is just reiterating, 12g1 is reiterating this mix and match principle of you can take any of the motions allowed under 12 and combine them together, okay? So I could say I want to bring up 12b2, 12b4, 12b6, as well as a 12e because I want more definite terms, even though you would definitely do a 12e before you brought up any of 12b, right? 12e being that definitive statement. Anyways, the point is, you can combine all of these together, but that's under 12g1. It's important to note under 12g2, I'm going to call that the one-shot rule. You got one shot. You can mix and match your Frankenstein of 12b or 12 rules, but you only really have one shot when you put that in, because once you do that, right, that one-shot rule, you waive whatever you didn't include. So let's say that I included in my answer to the complaint 1, 2, 3, 4, okay? 12e can sort of be introduced. It has to be introduced before everything because it wouldn't make sense if you did it after. So let's say I concluded a 12e and 12b 1 to 4. I put that in as my little Frankenstein monster as an answer to the complaint. right? But in doing that, I have now waived 12B5. Because we'll talk about 12B6 and 7 in a minute because they're exceptions to this rule. But theoretically, I could no longer say that they had an insufficient service of process due to 12G2, right? Our Frankenstein monster. You can't just add on another body part post submitting it, okay? Now, as I mentioned earlier, 12G2 does list an exception under 12H2 and 12H3. Now, Caroline, you're asking, Caroline, what the hell is 12H2 and 12H3? You didn't even get 12H1. And I would say, you're so right, Shoddy. You are so right. So, basically, 12H1 is the you didn't bring it up principle, right? So I like to think of this as, you didn't bring it up, why would we address this? Okay? So it's a failure to make a motion or failure to mention in a responsive pleading or amendment under 15A1 these defenses that you wanted to bring up, right? So that means that you have now waived those defenses. So if I brought up 1 to 4 but didn't bring up 5, that's a failure to make a motion for 12B5, right? Or failure to mention in our responsive pleading, 12B5, which means now we can't bring it up. No more. You can't bring up the insufficient service of process once you've submitted that claim. Cool? Cool. Right. So now that gets us to those exceptions of 12H2 and 12H3, right? So these are instances where these defenses are not waived, which would be 12B6, 12B7, and stating a legal defense to claim. So under 12H2, right, this is mentioning bringing up 12B6, which is failure to state a claim, 12B7, failure to join a party under 19C, almost got me slipping, and the ability to state a legal defense to a claim. Now, I believe that third one is a substantive law rule. I have to clarify, so don't take my word on that. I could also have read about it before starting this, but it's too late. Okay, it's too late. So the times that you are allowed when you can raise these unwaived defenses under 12H2, right, are pleadings that are ordered or in responsive pleading. So an ordered pleading under 7A, okay, a motion, right, under 12C, or at trial. Those are the 3 times that you can raise these unwaived defenses, which are, this is your moment to reply. Oh my God, you did so good. I'm so proud of you. Okay. Anyways, so that's 12H2. Those are the 3 times you can bring them up in terms of your unwaived defenses, which is responsive pleading or ordered pleading under 7A, a motion under 12C, or at trial. Okay? So that's 12H2. 12H3, it just elaborates a little bit on lack of subject matter jurisdiction, right? So 12H3 says, hey, at any time, if this court finds that your motion doesn't fall under subject matter jurisdiction, we have the right, to dismiss that action. So I'm going to read exactly what I wrote because I think I had a hard time understanding this one. 12H3, lack of subject matter jurisdiction. The court can dismiss that action at any time if it lacks subject matter jurisdiction. So if I brought up an action, a claim of action saying, hey, this person is actually a criminal in terms of like violent offenses, and we are in tax court, we're in tax court. I don't know what I'm saying is true. I'm making it up as I go a little bit because I sort of understand this one. I think I do. They're going to be like, we don't have subject matter jurisdiction over this, shoddy. And they're going to throw it out. Rightfully so, okay? Rightfully so. They say, we're not talking about this. This doesn't have anything to do with this claim right now. We're going to dismiss this. So then it basically goes away, right? Finally, last but not least, 12H3.1, right? All of this all of this situation right here we just talked about, all of this, right, has to be heard before we go to trial. So this is all pre-trial. Everything must be heard and decided before trial. Unless the court orders a deferral to the trial. So that would be one of those instances where the timing might be extended from like 30 days to 90 days or 30 to 60 to 90 days. It just depends on what the court decides. But this is my 15-minute Civ Pro, I was gonna say propaganda video, but I don't think this is propaganda. I would rather call this extravaganza. A Rule 12 extravaganza, if you will. All right, that's it. That's all I got. I hope you can hear this.